Hi, Susan. This is Joe.
Hey, good morning, everyone. Can you all hear me okay? You're in the room. That doesn't count. Can those of you who, okay, perfect. Hey, Rob.
Good afternoon.
So, welcome. Hopefully, this RAC meeting will go smoother than the last. I wanted to start by, again, apologizing for the chaos of last Monday and do a condensed version of introductions. In particular, introduce my team here. I'm Susan Myers. I'm the executive director of the commission. With me is Becky Mason. Becky is we don't know her title, a director of operations, something like that. Also with me is Stephanie Hefner. She is our curriculum and education coordinator. Molly Putnam, who is our accountability coordinator. And then in the room with me is our newest employee who joined us only 3 days ago, Casey Fenstermaker. Casey is going to be our new compliance and enforcement coordinator. So she's getting a speed course in our rulemaking. So rather than do if anyone online who would like to do an introduction didn't get the opportunity last week, etc., you can raise your hands. Thankfully, with Zoom this time, we have the hand raise process, so feel free to raise your hands if you would like to do an introduction. So we will simply go through, it looks like we have 25 participants, so that's likely a lot of the members of the RAC. We will go through and double check the roll and skip having to do an actual roll call here, if that is okay with everyone. So, primarily my plan for today is I collected all of the comments that everyone submitted by email in the survey. And these were comments not just from the RAC members, but from some other members of the public who wanted to have some input. So I did that and looked at the rules and kind of considered those comments and tried to streamline, fix, improve, hopefully not make worse, the rules as they were presented last week. I would like to represent them. Let's take a fresh look at them and talk about some of the big picture before we get too buried in small details.
Scott has his hand up.
Yeah, Scott?
So I guess it's a point of order.
Scott, I can't hear you.
What? Sorry, hold on.
Then needs to turn the volume up.
Oh, it's us.
It's us.
Try again.
Is that working? Okay, thank you. So I guess I have a point of order. Last meeting, this wasn't a hybrid meeting. This was a electronic meeting.
Yes.
And we were not able to, in my understanding right now, is that the live stream didn't work. And so we didn't meet the requirement of for public participation, which strikes me as a problem and a violation of the statute. So what is the cure that you're recommending to address that? Because the statute does allow for the cure. I'd like to know what that is, if there is one.
Last week.
We, at the last meeting, we did let the public call in so that they could listen and observe, but I take full responsibility. It personally, I think I probably should. And
The Teams Live was going, it's not the.
So yes, Teams
hold on,
Live.
sorry.
The Teams Live was going and some members were able to join, but not all members of the public were able to view it. Some were blocked. Those that reached out to us, we provided them with the phone number to call in. And so they were able to listen in on the meeting. But the live stream was not working.
But,
And the recording is now available as well. And we, right after the meeting, made sure that the meeting was published on our website and sent out an email to everyone that was in the interested parties list for administrative rules, to let them know that that meeting was posted and that they could submit comments to the rulemaking email.
And that's a sufficient, and you believe that to be the sufficient cure?
I am open to other suggestions for the cure. I'm also open if someone
No,
would
it
like
actually
to
sounds
call-
perfectly reasonable to me as
Yeah.
a cure for what
Yeah,
happened.
I mean, certainly if someone filed a complaint, other than having to figure out who would write the report, I would sign it as a recommendation that, yes, it was a violation and we did not do things properly. And evidence that it is easy to make these sorts of mistakes. And the best practice is to try to learn from them, which we are attempting to do.
Duly noted.
So with all of that being said, and again, I really do apologize on many levels for last week, not just the technical part. With all that being said, I wanted us to take a fresh look at some of the big picture items that we talked about last week. And specifically, I'd like us to start with who is a governing body. So let's just, rather than get buried in the details of all the definitions, let's talk about those policy issues of who does the public meetings law apply to. So let's jump into rule number 199-050-0010. Well, before we do that, does anyone else have any comments or questions that you want to share? Big approach versus jumping into policies and the rules themselves. Oh,
I'll share 199-050-0010.
okay. So as you'll see, what I did with the rule is I did my best to summarize in the table up front what everyone's comments and questions were, suggestions. And this document has been provided to you. It struck me, and policy-wise, is that a lot of the comments about the prior version of the rule raised questions about, suggested that I was trying to make governing bodies, mixing up governing body and public body, and creating more confusion or ambiguity. Again, not my intent. Some of that, unfortunately, rests with the language of public body in 192.610. I can't solve that language in these rules, so I have attempted here to revise these rules in a way that would make it clear that we are trying to apply the public meetings law to the specific types of governing bodies, whether they're the decision-making bodies, elected officials, etc., or the advisory bodies. That I'm not trying in these rules to make the public meetings law apply to staff or employees unless they're part of some other subcommittee or ad hoc committee that would qualify as a public body, as a governing body. So let me read through the statute or the proposed rule, and then let's discuss. So the revised version now reads, the public meetings law applies to the following types of governing bodies. Sorry, hold on a second.
Sorry. Justice. And I can't make it undo it, so I'm gonna stop the share and restitch share. I'm sorry. Okay, I'll try again. It's still being weird. Hold on. I apologize.
Thank you. Okay. The public meetings law applies to the following types of governing bodies. A, decision-making bodies. Decision-making body is a body with the authority to make decisions for the public body on policy or administration. A body meets this standard if its decision-making authority includes the power to exercise governmental power and act on behalf of the public body. Examples of a decision-making body include county commissions, city councils, school boards, port commissions, fire boards, transit boards, airport boards, utility boards, library boards, cemetery maintenance boards, county service district boards, soil and water conservation boards, and other special district boards. Subsection B, advisory bodies. An advisory body is a body with the authority to make recommendations to another governing body on policy or administration. Examples of advisory bodies include committees, subcommittees, task forces, state boards, and commissions. Subsection 2, the public meetings law does not apply to the following types of bodies. A, fact gathering. Bodies with the authority to only gather and provide factual information and without the authority to make decisions or recommendations to a governing body on policy or administration. But if the body is charged with determining the facts or deciding which competing factual information to provide, then the public meetings law applies to the body. B, advising individuals. Bodies with authority to make recommendations to an individual public official to assist that public official in making a decision or recommendation. But if the public official to whom the body reports lacks authority to act on the body's recommendations and must simply transmit the body's recommendations onto a governing body, then the public meetings law applies to the body. C, certain multi-jurisdiction bodies. Multi-jurisdictional bodies whose Oregon members do not constitute a majority of the governing body's voting members. So I'd like to, yes, Hasina.
Susan, in the top there where you list out a bunch of different types of special district boards, maybe for expedience, you might just want to cite ORS 198 special district statute types of boards I mean, that's if anybody went there, they would see
A long
a
list.
bunch.
Yeah, and I was thinking that I don't like making a list like this because inevitably I'm going to leave someone out. I mean, it's hard not to. So yeah, I think that's a good idea. Rob, I think you had your hand up. No?
I did, but it keeps going down. I'm not sure what's going on.
I'm sorry.
So I guess I just have a fundamental question about why we're even trying to define these terms. I mean, 192, 610, 5 and 6 have long defined governing bodies and public bodies, which then is what everything keys off of in 192, 630. And we have a whole body of case law, attorney general opinions, and the attorney general's manual that really have kind of fleshed all that out. And this seems like it's all new, and some of it's slightly different, like in B, it's particularly slightly different. And then 2B is slightly different. Why are we even doing this?
We do get a lot of questions. I mean, if the point of this is to provide clarity, there were two things I wanted to do. One, and may not be the clarity, but is to provide in a rule, here is who this applies to, because I think there are a lot of, yes, the big cities and the counties may have attorneys that can figure this out for them, but there are a lot of local and small towns and special districts that we get calls from all the time that don't really understand which of their subcommittees and ad hoc committees qualify as governing bodies. The second point is one that I think Scott raised the last time, which is I would like to use this rule, I don't think it's there yet, but to provide clarity to the governing bodies themselves on when they're interacting with staff, that doesn't mean staff is suddenly a governing body.
I'll just posit this and leave
Right.
it alone. And I'll posit this, which is we have a lot of developed law, case law, and attorney general opinions and attorney general's manuals about the existing statutory definitions that have really largely been in existence since 1973. And this introduces new language that I don't think adds clarity, and two, I think it gets us back to starting ground. So I understand where you're going. I just fundamentally disagree.
Okay. Hasina?
Yeah, I'd like to echo Rob's concern. Just I understand what your intent is, and it comes from a good place. But we do have statutory citations that define what a governing body is, and I know you get calls from small districts, but we would refer them right back to the statute and say this is what the statute says, and this just seems like it is coloring outside of the lines by confusing the issue more.
Okay. I guess part of my problem with the statute is, and with particularly the definition of public body in the statute, is that think about, and this will come up more, as you know, when we start talking about the training, the later rules dealing with the training and who is required to get the mandatory training or not. Is the definition of public body is, you know, the state, county, the regular public bodies, and then it includes and any boards or subcommittees, and I'll pull up the statute, but the question then becomes, is the public body only the entities, you know, that we would normally call the public body, right? The entities 174, 109, and, you know, state, county, local jurisdictions, etc. As opposed to public body in sub 6 here, 192.610 sub 6 says the state, any regional county council, county, city, or district, or any municipal or public corporation, or any board, department, commission, council, bureau, committee, or subcommittee, or advisory group or agency thereof. So if the public body is not just the county, the city, the state agency, this board, but if public body includes each of the subcommittees of this, that creates a problem, right? Because then you're treating each individual governing body as a separate public body. And you don't want to do that. I understand that. But then when we get to the training thing, the test for the training was mandatory training for every governing body of a public body that meets some threshold, $1 million, whatever it is, for its annual budget. Now, the argument back to us was, if the public body was, say, the city of St. Helens meets that threshold, so the city council would be subject to the training requirement. The planning commission of the city would be subject to the training requirement. But would all of the boards or commissions, are each of them being treated as a separate public body? Because I don't want to have to make each of those boards and commissions take that training. I mean, I do want them all to have the training, but I don't, you know, in terms of that whole mandatory within the term of their service, I think the intent when we were sitting around the table in 2805 was for that mandatory training to apply to the governing bodies of the big public body, right? Not to each subcommittee as a separate public body. And the whole point of this is the statute as written is confusing. And I know that there is well-established case law. I'm not trying to go beyond the case law here. But there is a lot of confusion out there. Okay, go ahead, Joe. You're muted. Joe Barker.
Yeah, thank
Sorry.
you. I think a public body would be like your like if a city appoints a planning commission and they're still required to post their notices and things like that. My understanding, and I could be completely wrong, and this is simplistically, the governing body are the elected officials or those that are appointed to fill the vacancy of the term. A public body would be like your planning commission, a historic preservation board that, and that's a little iffy on a historic preservation board because they do have rights and authorities unto themselves to make recommendations. Unless it comes to broad sweeping land use policies, then it would have to come before the governing body as a recommendation. Another aspect is that when you have the budget committee, that's actually a public body that makes a recommendation on the approved budget that has to be adopted by the governing body. So, I mean, I see where governing and public can be kind of iffy, but I think could be chiseled out to where it could be clarified.
Okay, and I don't disagree. Go ahead, Rob.
The problem is public meetings laws has existed since 1973 applies public meetings law only to the governing body of a public body. It's not
Right.
governing bodies and public bodies. That's how the law currently reads. And so we have a very broad definition in the case law and in the Attorney General's manual of what a governing body of a public body is. And again, I'm just going to interpose my objection to even defining these terms further because I think it adds more confusion for practitioners and folks that are used to public meetings law.
Okay. You said earlier you thought I was going beyond, basically, like in this definition, in this rule somewhere, that I was pushing the boundaries of what was existing law in terms of the statute and the case law and the AG manual. Can you help me understand where you think I'm going too far?
I can give you a couple of examples, but it would be my interpretation of what you've written, which may not be your interpretation, which I think emphasizes the point I'm trying to make, which is now we have new words that need to be interpreted and applied. If you go down a little further, I think you've got B, you've got some sort of advisory group, advising individuals. That second sentence, I'm not sure is entirely true in all circumstances, where you have a group of people that are advising a single official who may very well advise a governing body of a public body. That doesn't always necessarily constitute a group of people subject to the public meetings law, for example. But you may interpret that differently and those words differently. So I'm not suggesting that your interpretation of those words is wrong. What I'm suggesting is that my interpretation may also be wrong, which leads to more ambiguity. I think we're adding more ambiguity here than we're adding clarification. Just my opinion, just one person's opinion.
Okay. Other thoughts about that? I mean, really was trying to simply take what was in the AG manual and like I said from last week, I borrowed liberally from the city manual as well. In terms of those bodies that have a single, the governor, Secretary of State. So, Sarah.
Hi, thank you. I think maybe some of this stuff will be worked out through the training that we're going to be having and maybe keeping the rules a little more simple and concise. And this type of information could be fleshed out better in the training, which is forthcoming.
One of the things I had hoped to is, and maybe Scott, because Scott talked about it last week a little bit, was I had thought about adding either a subsection D here to section 2, or it could potentially be a separate section, but was to flesh out the rule on as I said in the beginning, that the public meetings law would not apply to staff. And so, for example, sorry, we see two people appearing as Rob Bovet. We're just trying to figure out why. Two Rob Bovets on screen.
I am not connected twice, so I'm sorry there's two Rob Bovets out there. Nobody should be subjected to that ever.
Good, okay, we've eliminated your duplicate, Rob.
Speak up.
Thankfully, we do know what you look like. So, what, does anyone have an opinion on creating a rule specifically, or a subsection here specifically to address that when a governing body is simply, when members of a governing body are meeting with staff? So say, for example, we have a complaint. I will not identify the jurisdiction. But we received a complaint that two members of a task force or a governing body were meeting with the city staff in a particular department to work on developing the agenda for the next governing body meeting and what policy matters would go on the agenda. And of course, the complainant wants that to be a violation. I would say, looking at my rules and looking at the statutes, that it is not, because it's not a quorum of the governing body, the task force, and meeting with staff meeting with the governing body is not what the law was intended to cover. And I'd like to have some sort of rule here that addresses what Scott said last time. How are we going to make sure that the rules here do not interfere with the ability to function with staff? So, Scott, did you have any further thoughts on that issue from last time?
I was thinking about that, and I'd elected not to put in a comment on Friday specific to it, because as Robin indicated earlier, a lot of this stuff has already been figured out either through case law or the manual. And so my concern with moving it forward, and I know I was the one who brought it up, and this sort of thing happens, but that if we spell that out, we miss something else, where then the rule becomes a problem, because you could have a complaint for another set of circumstances that's not addressed. If we're just saying that, if we're just using that public body definition, or the governing body definition and the public body definition, I think we're okay. I mean, I think you may get some complaints that are for, I think the example I used last time was, the tennis racket and pickleball people having disputes. You might get some complaints from them, but I don't think you can. I think those are pretty easily dismissed, because it's not a governing body or advisory. It's simply advisory to staff. So I think I was hoping for clarity, and I think what I actually ended up doing was muddling things. So my bad.
No, not at all. Because I mean, that is sort of one of the things we've wrestled with, and that was kind of what my sub D was going to say, is advisory to staff. I do see what you mean about sort of creating the rule and having it I don't want the rule to subsume existing case law. But at the same time, the Attorney General manual isn't, I mean, I've heard the arguments about whether it does apply to cities and local jurisdictions. I still think it would help to lay out what the manual says and what the case law says about who is and, who does the public meetings law apply to and who does it not. Tiffany.
I want to echo what other people are saying. I'm pretty concerned that if we start adding definitions here, that there's going to be unintended consequences. And I feel that the statute, as well as the Attorney General manual and cases, have already answered a lot of these questions. And so I guess if there's comments coming from the public or local jurisdictions or special districts that have questions, a training can be helpful, and then also answering the questions and directing them to the right area. I think if we're changing the rules, it's going to be more problematic, and it's going to make, the Attorney General opinions and cases kind of, how do they stand now? If we change it, then that's going to put those into question of how they still apply. I just think it's kind of unnecessary and not the best avenue to address the issue.
Is the consensus of the group that we simply shouldn't have a rule to try to clarify who the public meetings law applies to? That everyone seems to think that the statute as written is clarification enough?
Permission to speak?
Yeah, well, hold on a second, Joe. Let me hear from Chris.
I think it's okay to leave the rules broad with the guidance. I do think that we, especially as state staff, just talking from my perspective and from my colleagues' perspective, is we are doing levels of engagement that we've never done before, to really involve as many members of the public in what we do in setting policy and our work moving forward, which also means we have an unprecedented amount of advisory bodies engaged in our work as sanctioned by our governing body. And I think if we don't put this in the rules, it would be really helpful to have some clarifying guidance in the terms of opinions or guidance documents on how staff are going to apply this. We do have our DOJ that tells us what our direction is as an agency, and as the legal affairs manager for my agency, I can help with that. But the legal language is a little bit more difficult for staff in their everyday affairs to learn how it applies to them. And they do have a lot of questions. And I think more detailed guidance on some of these questions as it applies to advisory bodies is actually helpful in the practice of our work.
Yeah, and I mean, we can issue opinions and letters of advice now, but it's going to take a while we have the existing case law, we have the AG manual, which is what we're going to follow. It is our really only resource. But we don't have a body of our opinions ready to simply hand out to people and say, this is how we interpret this. So Joe.
I do like the idea of defining staff as not being part of or subject to the public meetings law. I would also clarify that intermediaries would be like your chief administrative officer or executive directors of planning commissions, that sort of thing, where they're actually before the city council or commission making the report and giving the recommendation and that sort of thing. That would sort of clarify and place a distinction between upper management and management. For example, you would not have an electrical line guy coming in to city council or the board of
Also-
supervisors.
Some city might, and I don't know that the rule that the public meetings law are where we could make that sort of distinction between upper and mid management or anything like that. It's not, it isn't really our role to make that distinction for some city. If a city wants to have this staff member or another come and make recommendations, that's not for me to address, right? It's the city's call.
Well, it sort of does, because now you're graying the line of whether it's a staff person that's just answering phone calls or someone putting up electrical lines versus someone who's an authority of that whole operating crew, whether it's
But the
overall
public
management
meetings law is
staff or
going to,
not.
right, but the public meetings law isn't applying to staff, it's applying to the members of the governing body.
I think we're on the same page. It's just that we're not using the same language.
That's quite possible. All right. Well, I guess we could do a poll if you want. Is there interest in having us look at streamlining this as opposed to scrapping it? My reasoning and my rationale for keeping it and working with it is that I understand that those of you who deal with the public meetings law on a frequent basis, either for your clients or for your constituents and so forth, are very well versed on what the AG manual says and what the case law says. But from my experience just in the last few months getting these complaints is that there are a lot of people out there that don't really know how who the public meetings law applies to. And so I think it would be helpful as a foundational issue to have a rule that says, here's who it applies to and here's who it does not apply to. So, Courtney.
So I think I have a really naive question, and it may be because I'm coming into this conversation after many of you worked on this legislation and have been kind of involved in this, but it seems to me that for those of us that support governing bodies that have been using public meetings law, there's a difference there versus kind of what the state's doing and all the different departments in the state. And so, I mean, to me, it doesn't make sense to create more rules, but it does make sense to have some sort of dummy, guidance 101, here's what it applies to based on what already exists. And so rather than trying to create rules, maybe it's really a focus on that training piece and creating those guidelines. And that's just for me kind of standing out here listening to this and wondering if we're trying to solve a problem that exists because this is new for some people and not for others.
That valid point. I mean, some of it is that obviously there have never been any rules there because there was no one enforcing it other than the court system. All right, Sherry.
For those of us who are new, I think it would be nice to have the clarification. I understand you don't want to get way out there, but I think it would help to have clarification. Some of us, this is our first little adventure, so maybe of many to come, but it would just help us to have that clarification on there. Especially if you have a brand new council like we did. It was difficult.
Yeah. Sherry's council is going to be an example later today. So, we can do a poll or just,
We could just have them raise their hand and we can just count who raises. how many
okay,
raise their
all right,
hand.
so I'll do a sort of consensus question, and I would ask you to raise your hand. My staff will count up the hands. And so the question is, should we include some sort of rule, not necessarily what's on the page here, but a rule that clarifies who the public meetings law, what governing bodies it applies to and what it does not? So raise your hand if you think we should have some kind of rule to address this. Okay, so let me consider that and talk to DOJ and see what they have to say, and I'll get back to you on it. Any other comments or questions about this?
Gabe put a comment in the
Yeah.
chat saying they are changing out the lights at my office, so it is dark and very loud right now. Therefore, I'm using the chat. I've been on a city council for almost 4 years and a deputy city clerk for almost 2. And I didn't know the AG manual existed until a few months ago. I think a clarification would be good for the public and new officials to understand what their role is.
Okay, Joe, I don't know if you have your hand raised from the poll or if it's another question or comment.
Sorry, I was a little delayed there. I had
That's
my
okay.
hand raised for the poll.
That's okay.
But I do agree with newbies. They do require extensive knowledge and training and a go-to manual. Even some more seasoned veterans could require a refresher course, but nothing personal there.
Sorry, Sarah?
I just want to agree with that again. I think the training is kind of the common theme here. And while we want to stick to what the House Bill 2805 gave this group the permissions to go forth with, stay focused on that. And I think the training is very much wanted and needed for both new people as well as people who are more seasoned in this topic. I think that will really help a lot, answer a lot of these questions that we're trying to kind of get at through this rulemaking process. We just need to stay focused on keeping it simplistic and focused, and then allow that training to kind of help people understand the topics.
All right, thank you. Any other thoughts or comments on the 0010 rule? Okay, then let's skip over to let's take a break and when we come back, we will move forward with the 0015 rule, meeting subject to public meetings law. So let's take a 10-minute break.
You wanna go outside, baby girl? You gotta go pee pee.
Okay, everyone, sorry about the delay. We are still working with Jeb Blandine to get him in. So we can either extend our pause for a short while longer. We have staff working with him to try to do that, but to get him in. So in the meantime, I would like to move on to Rule 199-050-5. And specifically, let's continue our discussion about work sessions. So, accepting that everyone may call these something different. I did make note of some very helpful comments and insightful comments in the suggestions over the week regarding not defining work sessions in a way that would limit the ability to make decisions in a work session, that it's not in the statute, and I fully understand and accept that. Beyond having a name for them, what I will say is, ooh, pretty picture. Oh, thanks, Joe. What I will say is that in my experience and in the cases that come before me, there are a lot of governing bodies are holding these sort of fact-gathering informational sessions. And I'm not simply saying fact-gathering in general, but to gather facts related to a decision that the governing body needs to make. And most of the groups that I deal with have come before me, have referred to them as either work sessions or workshops, but I recognize that different groups may call them different things. I want to simply say that it would be helpful to come up with a term, because while I recognize that there are only 3 types of meetings, a work session is simply one of those types of meetings. What we don't have is clarity for people that a work session is still a public meeting.
Okay. Thank you. Go ahead.
Jeb, there you are. Welcome, Jeb. I'm so sorry for any of the confusion. No, you're muted.
Yeah, high-tech stuff.
Well, as is very clear, tech is not my strong suit. So I was talking about why I think we need work session, and that as a defined term, and why we need to talk about it. So the types of meetings that governing bodies out there are having are, under the law, the 3 types. Those are the only types: regular, special, emergency. So if you're having a standalone executive session, it's still one of those 3 types. If you're having a work session, workshop, planning session, whatever you choose to call it, it is still one of those 3 types. And I'm not trying to change that or create a new type. But what has happened is a lot of governing bodies may have what they're calling work sessions and not notice them as public meetings, as special meetings or regular meetings. Yes, the bigger ones, most of them who have legal counsel or are very experienced staff, will notice them as a public meeting, but a lot of the others don't. And I would like to provide some clarity for them so that they don't get caught up in a public meetings violation if it's not necessary, if we can provide some clarity. So, thoughts? Joe?
In your first block on 10, where it says, I believe that is an informational meeting used to explore topics at a deeper level and or review factual information in a meeting where decisions are not made but may be discussed, evaluated, or deliberated. Are we on the same page? Apparently not. It's right after 9. Yeah, right here. And actually you can see me pointing.
Yeah,
It's
that's
the
okay.
second, it's the second last square on the page.
Okay.
I think that's a good definition.
I don't disagree. I do think there would be justifiable pushback at including the decisions are not made. Yes, in my experience of work sessions, most often they were treated as meetings where information is presented but decisions are not made. But I don't know that I would want to say that in a rule because there is no law that says a governing body cannot make a decision in a work session.
Well, the problem I have with that is that there may be abuse for using a work session and passing agendas and voting on things, and the public would not be fully aware. And all of a sudden they're caught flat-footed a year or so later. I'm talking about the public now. I
which
think
is
that
why I want to make sure people understand.
that's
Rob,
that's the
Beth,
reason why I
yeah.
think this whole definition is very good, because you're discussing, you're evaluating and deliberating, but you're not making a formal decision. You're not taking a formal vote.
Okay. Rob, did you have something to add?
I did. I just wanted to note, as I noted last time, that phrase, work session, means different things to different bodies in different contexts. For my board, it means kind of what you've defined it, although not quite under our charter and our public meetings law approach. A work session means something where they're not making a decision. However, for example, the legislature operates off of Mason's rules, not Robert's rules. And the only decisions a legislative committee makes is during a work session. And so you would essentially, if this were enacted, you would stop the legislature from functioning.
Yeah, I mean, and I'm not tied to using the term work session. I mean, I recognize we may need to explore whether we can call it something else. Can we reach consensus on a term that would be broad enough to cover it for everyone without causing the unintended consequence that you identify for the legislature? I've seen it called a workshop, an informational session, etc. So let's keep going. Jeb.
Yes, just two things. If I could respond to what I heard from an earlier discussion about public body and governing body, I think Rob was talking about that. As I understand the law, every committee, subcommittee, subcommittee, any group that is named in any way by a higher governing body is a public body. It may or may not be subject to the open meetings law at one type of gathering versus another, but it is a public body and has a governing body of that public body. And so that's, I kind of agree with Rob's earlier discussion of the confusion of talking about a public body not being bound by law, or confusion between what is a public body and a governing body. On the discussion of work session, I've just always objected, always for decades, to even the use of the term. The fact that it's used differently by different public bodies and governing bodies, councils and commissions is all the more reason that it shouldn't be in the law. People simply do not have, there doesn't seem to be any reason to define a public body when somebody's going to come together for a meeting. A meeting is a meeting. And I think that people understand what is a meeting under the law. And when you start throwing out other language as if it's a completely different kind of meeting that's not subject to the law, I think it gets very confusing. And the last piece of that is that I believe that when people are doing fact gathering, they are moving towards, even if they're simply gathering information, they're deliberating towards what will be a decision. Ultimately, if they're going to pass some report along to the governing body that created them. And it's the deliberation that is part of the decision-making process, not the fact that they may or may not make a by vote decision. So it gets very difficult if you start saying, well, it's not bound by the law if they're not going to make a decision. So I think that these rules serve to, confuse people in all kinds of ways potentially.
Okay, Courtney.
Well, I agree. And what I was going to say is that it seems to me that instead of defining the types of meetings, you define that the gathering of a quorum is considered a public meeting, and whether it's a regular meeting, a special meeting, whatever the meeting is, whatever you call it, it's that gathering of the quorum that makes it a public meeting.
We also have a comment that says under executive session, it covers deliberation only. Work sessions should state the same if included in definitions. And that was from Chris Wright, not O'Grady.
Okay, so let me pause and address some of that before we move on. So in terms of Courtney, I don't disagree. It is the gathering, it is the convening of a quorum of a governing body that makes something into a meeting to discuss or deliberate on matters subject to their authority. I have just seen so many times groups that hold these meetings as regardless of what they call them. And like I said, while work session is the term that I think is most commonly used, I agree with you. I don't want to create a problem given that that term is used differently by the legislature and other groups. So I'm more than willing to kind of look at other options. In terms of Chris and the deliberation versus decision, I'm not sure I can go there, Chris. And that is because the distinction between executive session and work session, one, work session is not in the statute, whereas the executive session has that specific statute saying that you can't make a final decision in executive session. So I think the exception, the language of how work session, whatever you call it, is used, is to gather information in a regular or public or special or even emergency potentially meeting that is related to something subject to the governing body's decision or deliberation. And part of the reason I think we do need it in here in some fashion is because of that exception in 691 MA, where we have the exception saying fact gathering discussions or meetings are not subject to public meetings law if they're not related to decisions or deliberations. So we have sort of a long history of some groups thinking that work sessions are not meetings. And now we have this exception that says fact gathering is not subject to public meetings law, and they don't read the second part of the exception. If you have a fact gathering that is related to a matter subject to the governing body's decision or deliberation, it is a public meeting.
Corey Tate had a comment in the text just saying, I like Courtney's statement regarding a gathering of quorum. We always held public meetings for work session, goal setting, and work studies. Courtney also commented, the training will be helpful for these groups.
Training will be helpful for everyone. Go ahead, Joe.
I would, if I may, I would like to address Rob on the work session for the second last box. If there was the phrase exempting legislature's work session, would that definition work for you?
It would work for me and my client, but not for many cities. And I know a couple of other counties who have work sessions and take action, make decisions during work sessions. So it really is a mix and match.
I tried.
No, that's okay. I don't. So I don't know if we can explore whether there are other ways of describing it, of creating sort of big tent. I get Jeb's comment, and that was kind of what I was trying to accomplish in the rule itself. Can you scroll down to the rule?
Yes, hold on. Maybe.
Okay, no. Oh, this is 005. No, I wanted 15.
Oh, sorry. The comments about work session were in 005,
Okay.
that's why. So just one moment. Nope.
Okay. So in subsection 1, that was why I was trying to, I didn't want to include executive sessions and work sessions as types of meetings, because I do recognize that they are simply terms that we use for some meetings, but the only types of meetings are the main three. If we could come up with another term or way of describing what a work session is, and we take out, obviously, in the definition, anything about making final decisions, is there still objection to being able to explain to people in the rule that a meeting to gather facts subject on a matter that is subject to the decision or deliberation of the governing body is a public meeting subject to the public meetings law, regardless of what you're calling it? Go ahead, Gabe.
Yeah, hopefully there won't be any pounding in the background. So I really actually think that you're right for needing this definition. I don't, as we've discussed a lot, I don't think work session's the right word for it, but I think that emphasizing that if if counselors get a chance to talk about something, they're gonna talk about it, and that is deliberations. So, oh, there we go. So I do want to also say thank you for taking out the language that defined that restricted it, restricted work sessions to not taking
decision.
action. Yeah,
Yeah.
because that's really important to me and the people I represent. So I think that I understand where you're coming from with this definition, and if we can find another term, it makes sense to me.
Yeah, and I think what your comments over the week did help really clarify that sort of decision-making thing. Most of the time, back when I had clients at school districts, what they called work sessions, they had sort of either a policy or it was in other states, there's possibly a law that said, you know, you can't make decisions. And I think that is the practice, but it is not the law. And I'm fine with taking out the decision-making thing. Also fine with exploring other names. Sherry Kinsey, who's one of our RAC members, I think it was your city. This is the example of the type of work session that is in my head, and that is city is considering an ordinance about homeless camping. And as part of that process, the city council holds a work session. Thankfully, even though the complaint was filed, they had noticed it as a properly noticed public meeting. A work session to get testimony and input from like an ODFW person or someone from state lands, I forget who they had testifying and providing information. And they also had the city's legal counsel providing information on here are what different types of ordinances other jurisdictions have. They weren't making the decision, they were simply getting all of that information in. That was it was the perfect example of a work session. They weren't making, and in this case, they could have probably made the decision, but they didn't. My problem is, while that city had a lawyer who advised them to notice it as a public meeting, there are other cities, not cities, but other jurisdictions that don't. They don't know.
We had to thank our city manager on that one.
And the case was dismissed, as it should be. Any other thoughts or suggestions about work sessions? Matthew, sorry. Matthew Cole, you had your hand up?
Yes, thank you.
Oh,
I'm just wondering whether if we take out the term work session there and just think about replacing it with informational gathering, because to me there's a difference between factual or educational and information gathering. I mean, informational gathering, it's part of one of the definitions on decision-making process, right? I mean, that's gathering information that's leading up to a decision. I see the purely factual and educational as a separate type of discussion that may come or be held by a governing body. But I'm just wondering whether, rather than focusing on a particular term, but maybe explaining what the issue is would help here. And if I can then, because we've got it down in 2C, C2, where then you've got it with factional educational, and then there's a caveat out of that for it being non-exempt. And that part was a little confusing.
Mhm. I like this. I mean, I like this approach because it does sort of go where my head was going in terms of the 691 MA exception language, which is trying to come up with something to distinguish those types of informational meetings from the meetings that are exempt. And so maybe instead of obviously we can play with coming up with a term, whether it is informational session, informational workshop, informational gathering, whatever. And then more tightly in that term, define it to gathering information as part of a decision-making process, which then takes it out of that exemption. I think that's where my head is. Anyone else before we jump back to Joe? All right, go for it, Joe.
Would retreats fall in that? Because library districts, from my understanding, they can hold work sessions as well as retreats. And from last week's conversation, if I remember correctly, retreats have a tendency of making sort of like policy and forward future looking goals that they want to set. I mean, there's a whole bunch of synonymous terms dealing with scoping, work session, works council, if you want to jumping across the pond, retreats, fact finding, information.
The problem, Joe, is I think retreats carries a connotation that is very distinct from what most people see as a work session or an information session or a planning session. And I think retreats themselves may be exempt, depending on what it is a group is doing at a retreat. But so I wouldn't want to confuse sort of the actual something that is a public meeting to gather information for a decision to be made with something that may be exempt.
Well, Susan, all I gotta say is you opened up a right can of good worms.
I often do. Okay, so all right. Let's I guess we could do a poll on, or I can just ask people to send me some suggestions if we were to keep the concept, but clarify it to what are we going to call it? And how might we clarify it in a way? I like what Matthew kind of suggested of an information gathering session or something like that.
We can add a specific question suggesting.
Okay, in the survey.
Yeah.
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 We will add that to the survey to get your suggestions on what would you call such a meeting or portion of a meeting. Okay, so that was subsection 1. So let's scroll down and see more of subsection 2. Okay. So I will read subsection 2 and then we can start the discussion. So 2, the public meetings law does not apply to on-site inspections of projects or programs, provided the members of the governing body do not engage in discussion or deliberation. B, attendance of members of a governing body at a national, regional, or state association to which the public body or the members belong, provided the members do not engage in discussion or deliberation. And C, communications between or among members of a governing body, including a quorum of members that are, well,
Sorry, my screen is flashing.
A, purely factual or educational in nature and that convey no deliberation or decision on any matter that might reasonably come before the governing body. B, not related to any matter that at any time could reasonably be foreseen to come before the governing body for deliberation or decision. Or C, non-substantive in nature, such as communication relating to scheduling leaves of absence or other similar matters. Then I have sub I and sub 2 examples of communication exempt from the public meetings law under this subsection C include social gatherings, training sessions, and retreats, so long as the subjects communicated or discussed do not include matters that may reasonably be expected to come before the governing body for deliberation or decision. And sub 2, factual or educational communications that relate to a governing body's decision-making process or involve matters that could reasonably come before a governing body for decision or deliberation are not exempt from the public meetings law under this subsection. Communications relating to such factual matters or that involve information gathering related to a governing body's decision-making process must take place in a properly noticed, substitute the phrase, work session. And then subsection D, any other matters that are listed in ORS 192.690. And then I will wrap up with 3 and we can discuss. 3 is just emphasizing a private meeting where a quorum of the governing body engages in discussions or communications that are part of the governing body's decision-making process, or where they make, I left out where, or makes a decision on an item of business within the authority of the governing body, violates the public meetings law. Yeah, go ahead, Rob.
You go back up to the top, there's another number of examples here that are similar to what I was saying before about changing existing law. So if for example, I'll just take 2B, that I think is an attempt to plug in what's currently in 192.610, a sub 7 paragraph B. We call it informally, we call it the AOC LOC exception. So AOC members and LOC members can go to their annual conferences and do all that stuff. But the way you've crafted it here, you added words. And I understand you're trying to clarify, but what this would functionally do is it would shut down AOC's decision-making process. I can't speak for LOC, but I suspect the same. My previous job, I had 120 bosses. They were the 120 elected county commissioners for Oregon. And they met once a year at that conference, and they decided things for the organization. It was all public meeting, all publicly noticed. But they deliberated, they decided, they made decisions at these conferences at those particular sessions. So this will just shut that down. And I'm not sure really why we're doing all this stuff when most of these terms and phrases from the 73 original public meetings law have been already interpreted and explained. And I think we're just creating a lot of unintended consequences throughout this rule as well.
It's not my intent to prevent voting at the conferences.
But they engage in deliberation and
Right.
discussion and debate and decision making. They do these things at the AOC conference that you've described here, which is not part of the exception that's in Oregon public meetings law for that reason. It goes beyond that and describes it further. And I get your true intentions here. I do. Trust me, I do. But I think there's just unintended consequences throughout all of this that is gonna not work.
Therese.
Yeah, I wanted to mention, let's see, 2C, well, the sub 2. So when you say factual or educational communications that relate to a governing body decision-making process, that paragraph, for clarity's sake, to me, it seems confusing to, in a list of exceptions, to include an exception to the exception, if that makes sense. Like it throws it off. So I find it confusing to have something in there that suddenly talks about when it does apply. So my recommendation would be to kind of not structure it that way. And then I don't fully understood Rob's comment about 2 sub B. So maybe I'm not reading that section correctly, but it seems as though what you're saying here is members of a governing body. So like, for example, for the Oregon School Boards Association, we have our annual convention. And at that you have, quorum of potentially 305 governing bodies all present in the same place, much like the AOC-LLC conventions, right? And there are some decisions made by that body at that convention, but the individual governing bodies aren't making decisions.
It didn't say that. It just says, if you just read it literally, attendance of members of a governing body at a state association to which the public body of the members belong, which is true for my board, provided the members do not engage in discussion and deliberation. Well, they do, as part of the AOC governing body. All 120 of them do. Now, we could put in more words here to make it clear that it's not when they're wearing their hat as members of the local governing body. But then again, we're just adding more words and more. I'm not sure why we're doing any of the redefining of terms and phrases in the public meetings law. I think we're just creating a lot of potential problems.
Yeah. Well, thank you for clarifying that. I guess I can see some, I see some value in making it more accessible and easy to understand for elected members, people who aren't attorneys, like Rob and myself, who are used to going to the case law and to the Attorney General's manual. I can see the value in making it clearer. So yeah, but I do get to go back.
But see, that's not out of the manual. I mean, that's just straight out of the statute. It's in sub 6 of the definitions. So, I mean, this just redefines what's in sub 6, but puts more limitations on it, which in the example I gave eviscerates the exception itself.
Okay.
Yeah.
I'd agree with Rob on that adding those words after having defined discussion and deliberation in the previous rule means that everybody that goes to a convention is going to be in violation of these rules. And it just seems an unnecessary phrase to add that. If they go to one of these meetings and a quorum gets together and they have an illegal meeting and make decisions, we're going to find out about it. It hasn't been a problem without that language all these years. I don't know why we'd need it now.
Well, I think debatable whether it's been a problem. Has it been a problem that people have been willing to pay to go to court about? Maybe not. But yeah, we get calls a lot.
Yeah, I just look at your definition of discussion.
Yeah.
And know that unless there's more to this, that everybody will be in violation under that definition of discussion, which is simply to receive or respond to communications.
Yeah. Okay, Scott?
So the league is an ORS 190, which means the league itself is a public body.
Yeah.
We notice our board meetings are advisory to the board, our committee meetings and our business meetings, conferences as well, where they'll actually take a voting action. So they would be covered in this, I mean, as a public body already. So this actually, I think, this may actually dilute the requirements that we're operating under now. I'd have to game this out with some of our legal counsel, but these associations are in fact public bodies in and of themselves. So we don't need to call out that attendance is, because they're going to operate under, well, one, they can't deliberate on stuff for their cities, but they're also required as voting members of the LOC to participate as voting members of a public body because of the 190 status. I don't know how the other association, I don't think all of the associations are 190s, but I'm not sure what this gets us, and it may actually be counter to what you're trying to do.
Good point. I mean, truly what I'm trying to do is prevent 5 members of the city council, or 4, or however many, while attending the LOC conference, from not connected with LOC, but having an illegal meeting, which I understand that the illegal meeting's already illegal, so do I need to define it separately as an illegal meeting? But that they not think simply because there's an exception to go attend a conference, that means they can start discussing their city's business.
Well, they should understand that now, and then adding this exemption in there confuses. I think it actually confuses an area where I mean, I can't speak for everybody else, where we've trained our members.
Yeah.
Our training is, well, as you've seen, we tell them that is not okay. Their staff who usually attend these that also help police that if a spontaneous meeting does look like it's going to form. So I'm not sure what this, I'm not sure that this does what you want it to. And it may be counter.
Okay. Okay, Chris Wright added to the comments that the use of quorum in 2C is confusing. Some may read it as an exception to public meetings law. And that is the language in 2C that says communication between or among members of a governing body, including a quorum of members that are, and then I think I agree with you, Chris. So, or at least the including part, arguably communication between, I guess the dilemma, of course, is that communications between or among less than a quorum of a governing body don't constitute a meeting subject to the public meetings law, which I think that's why I put the quorum in here, saying that if you do have a quorum and they're discussing any of the following, it's still exempt, is what I'm trying to say, but Joe.
I have an alternative to 2B. After the comma, put providing the local governing body members do not engage in discussion or deliberation. I mean, I'm just inserting local governing body as distinguished from the national, regional, or state to address Scott's concern, Rob's concern, and Jeb's concern as well by tying hands.
I'm not sure that does, though. I mean, if the constituents of the LOC as the entity are the local city councils, they may be there as each local is a member of the overall voting membership at the conference. So I'm not sure that would solve that problem. All right. Other comments? Down a little.
How far did you want me to go?
That's good. So the sub I and sub 2I. I think, especially in my sub 2, this may go toward what Matthew suggested earlier, which was distinguishing maybe between the factual or educational communications, language in 691 1MA, from an informational gathering session, and this, I think this could be tweaked to clarify that distinction. Recognizing, I think, Therese, you're right, and about exception to exception, like the structure of this could be changed. Plus, I don't like getting so many subsets, etc. No other thoughts?
Due for a break.
I know, it's almost time. Will you scroll down just a little further?
Yes, of course.
No, that was it. All right, let's take one more 10-minute break, and then we will look at the new proposed rule about serial communications and talk about who counts as an intermediary and who does not.
Hey, Miss Myers.
Hi, Joe.
Oh, actually, it's Chris.
Oh, sorry, Chris. It's,
Okay.
I was used to Joe.
I love it. I should probably turn on my video so you can see
There
me.
you are.
Oh, hello,
Can you
Joe.
remind me of where you're from, Newburgh? Is that right? Okay,
From Newburgh. I'm one of the planning commissioners there.
that's what it was.
The a quorum of the members of a governing, I think.
Oh, I'm missing body. Yeah. Sorry.
Oh no. I'm
I can put that in there.
I'm really bad about typos when I go too fast. Our secretary in Newburgh, we always go back and forth because we catch each other doing it all the time. It's all good. No, I thank you. You're doing great. Especially with such a newbies and very, very well
Experienced.
experienced
Yeah.
members. So you are doing wonderful. Oh, you are.
I'm mostly tired. I have a report to write. So, not connected to any of these rules. Sorry. Jeb, you had something to add, or you, before, is it about the rule, or? Okay, all right. We'll wait until I read it and get it on the record, and then we'll talk.
Okay. You want me to wait
Yeah, let me read, I'll read the new proposed rule, and then we can have discussion. So to start with, so I've proposed a new rule 199.050-0020, serial communications prohibited. Let me read it. Subsection 1. A quorum of the members of a governing body must not, outside of a meeting conducted in compliance with the public meetings law, use a series of communications of any kind, directly or through intermediaries, to decide or deliberate on any item of business that is within the subject matter of the governing body. Subsection 2. The prohibitions in Section 1 apply to using any one or a combination of the following methods of communication. A, in-person, B, telephone calls, C, videos, video conferencing, or electronic video applications, D, written communications, E, electronic written communications, including emails, texts, and other written electronic applications, F, use of one or more intermediaries to convey information among members. An intermediary includes members of the governing body itself, and G, any other means of conveying information. Go for it, Jeb.
Thank you, Susan. With apologies, I wanted to just do a real quick revisit on number 2 that we talked about before.
Okay.
I appreciate that, what you're trying to do about these potentially illegal meetings that take place. And it might be that the language in those exemptions does not apply to situations where a governing body would be holding a meeting that is bound by the rules of the public meetings law, as opposed to just saying they can't discuss or they can't deliberate. If 2 members of a 15-member committee, if they have the task of making a recommendation, are a governing body. And so if those 2 members get into a deliberation of that issue at some meeting, they're holding a meeting. So in other words, I just am suggesting there might be some language rather than prohibiting discussion or deliberation and saying that it's exempt unless they're holding a meeting that is covered by the public meetings law. So I won't belabor that. I just wanted to get that in before you moved on. Thank you.
Okay. So, okay, Scott.
So looking at the language in 1, I would suggest in that first sentence, a quorum of the members of a governing body must not intentionally or knowingly. than outside of a meeting conducted in compliance, Because you have.
Yeah.
Because I mean, by definition, the serial meeting is not the public body acting, it is individuals. And the knowing and the intentional or knowing standard is the key here. If you have one member who's going around to the rest of the governing body, sans without the knowledge of the others, where's the violation? I would argue that it's the individual who's going from member to member to member.
Yeah, I mean, difficulty is intent and having intentional or knowing in the statute, I mean, in the rule, I don't disagree with you about the point of the serial communication prohibition is to avoid the handy or substitute whatever body you want.
I mean, handy isn't a great example because in handy,
I agree, it really wasn't.
Well, you had like people screaming at each other from closed offices thinking they weren't convening. I mean, this isn't that was.
Yeah, I mean, I think the more frequent common example of this, and my dilemma is when does intent come into it, is you have 7-member board and, 4 of the 7 start emailing each other or even worse, you have a 7-member board and you have 2 members who are meeting. They're allowed to meet and talk. You have 2 other members who are playing golf. And then there's, 1 member who's communicating with both and conveying information back and forth.
But you're the ethics commission. Someone doesn't unintentionally commit unethical behavior. They do it I mean, you can make that's the difference between, an error and a mistake. You're talking about a member who the way this is written, you can have an elected official, a member of a governing body with no knowledge of any other communication be in violation. And that's where we're going to have a problem. They have to know that the case that brought us here, that drove this bill, that was individuals who knew what they were doing. How do you say that a person with no knowledge of subsequent other communications was part of a serial meeting if that person only talked to, and to their knowledge, the only communication was between them and one other member and not a quorum? Because you could have somebody who is actually going to great lengths to avoid this, find themselves with a violation unintentionally. And now you're talking about fines and people's reputations. So yeah, we're gonna hold fast on knowing and on some form of knowing or intentional.
Okay. I'm not necessarily opposed to it. I think I have to figure out how to make it work, but I see your point, so, okay. Therese.
I agree with Scott's point that if if this is drafted as though it's a violation by a quorum, then, there does need to be that kind of intentional element so that you're not imputing knowledge to those, like if in the scenario that Scott just mentioned, where there's like one intermediary kind of having those discussions without making it clear to the other members that they're happening, You don't want to set it up so that there's liability for those who are ignorant of it. I agree.
Joe.
I agree with Scott that there should be intentional and knowing, because after all, that's what training's all about. I would also add under 2H for social media. You know, like, simply because social media is actually a separate chapter or book within Locke's meeting manuals.
Okay, Chris, right added in the chat, said that under subsection 1, I think the word notice should be in front of meetings. Clearly typing was not my strong suit. Even though you include conducted in compliance with public meetings law. Yes, it should, outside of a properly noticed meeting conducted in compliance with public meetings law. That might get a little too redundant, but I think a valid point. Any thoughts? If we included the knowing and intentional language here, any other thoughts or concerns about spelling out sort of how such serial communications would be prohibited?
Chris wrote a larger comment. She said, this is not on the agenda today, but I did want to raise this because it is of interest to staff and our growing body. Will the draft rules cover the additional oversight and liability now attached to violations of this body of law? I think additional clarification via rule would be helpful on the standards used to determine appropriate remedies. Rule on this could even go into unintended/unintentional violations.
Yes, so broken the rules into these tranches. So this was the foundational stuff. Then we have some of the complaint and the detailed stuff for like electronic meetings, etc. And we have a section on the grievance process and on the commission's complaint and sanction process. So right now, for example, in the administrative rules, we have a penalty matrix that included, because we've had executive sessions since '93, so it included a section for executive session violations. And how the penalty matrix worked was kind of assigning points and deducting points depending on categories, which is, the number of violations, whether something was arguably knowing and intentional, were you acting in accordance with policy or on advice of counsel? There's a long list. So one of the rules will be proposing, I'm debating right now whether I can keep that as part of one matrix and just expand it to incorporate public meetings law instead of just executive session law. And that's where my head is right now, but we would certainly, having a knowing or intentional violation would be one of the factors considered in the matrix. But that doesn't excuse that we may need to have that be part of the rule itself as well.
I think that would actually be very important to then distinguish it and put it in here because of the result if you have somebody that does do serial communications and more than once. That also aligns with the matrix of fines or results.
Yeah. Yeah. Okay, can we move over to the 005 definitions? I want to talk briefly about intermediaries and see if people have thoughts. And I don't necessarily want to go through, we will continue tweaking the definitions as needed. But I wanted to, given that intermediary is connected to the idea of serial communications and so forth, I wanted to see if anyone had thoughts about, does this definition need to be narrowed further or broadened? So the definition currently reads, intermediary means a person who facilitates communications or discussion among members of a governing body by sharing information received from a member or members of the governing body with other members of the governing body. And the term intermediary includes a member of the governing body.
Is there one of the submissions commenting about intermediary and intermediaries when it came to staff?
Let's scroll up. It will be up at the top. Okay.
Because I think they had a good point that to do with staff. Okay.
Let me go to the very beginning first.
Okay.
And so the first comment there was about the use of the term facilitate makes me think about the need for it to be intentional. So this, I think, goes to precisely what Scott was saying. So an alternative, one or more persons who knowingly or unknowingly facilitate communication. I mean, an intermediary, may, as Scott pointed out, may not know that they are, you know, conveying and creating the convening of an illegal meeting. So I wouldn't define the intermediary of having, needing to have intent, but rather the intent of the person who is using the intermediary is what is essential. It's the governing body member's intent. Go ahead, Scott.
You know, I almost pulled my hand down, but I mean, the interesting thing here is that the intermediary actually has no liability here.
No, not at all.
It's the
only liability
intermediary
is the public
does the intermediate have to be acting on behalf of?
I don't know that they would. So it's the governing body members who are responsible for following public meetings law. Intermediary is no one else is on the hook. If board members say we make it truly old-fashioned and we have board members handing notes to staff and saying, take this note over to board member A and bring me back their response.
Yeah, that's a bad.
Staff is acting as, you know, an intermediary. I don't know. Let me think about it a little bit. Gabe, go ahead.
Yeah, I think to Scott's point, an example I can think of is a member of the general public coming up to me. This hasn't happened, but this is what I can think of and saying, I've talked to counselors A, B, and C, and they're all against this. I need someone to be for this. Can you vote yes? And now it's like, well, if I'm a 7-member board, I now know, and suddenly it happened to me, and I have no control over what just happened, and I don't know who's
Yeah, and I don't want that.
going
Yeah.
Yeah.
Courtney did comment in the comments that she likes the alternative definition provided.
The one or more persons who knowingly or unknowingly facilitate.
Joe has her hand up.
Oh, go ahead, Joe.
I agree with Scott, but I have one distinction. I do agree with the fact that the intermediary has to knowingly, because that's, I'm sorry, I got a little lost here, listening to comments. Could you refresh my memory, Scott? You were discussing that an intermediary has no liability, but you raised the question of, is it at the direction of?
Yeah, so are they acting on behalf? So the public
On
body
behalf of.
members have the liability, but so
Right.
in order to get to be an intermediate, you have to be acting on behalf of
Right,
the
and
body
that's,
or members of the public body.
and in my mind, that speaks to intentional and knowingly.
I am equating it with 040. So in the ethics statutes in 244.040, prohibited use of office or position. It provides that a public official may not use or attempt to use their position to obtain a financial gain that they would not otherwise have an opportunity to obtain. And I think what we need here is may not a governing body member, that the intent language we need is similar to that the governing body members may not use or attempt to use any of the list of serial communication stuff, including an intermediary, to communicate with their fellow governing body members, with a quorum of their fellow governing body members on a matter subject to decision.
Susan, I agree with that, but I also have an example similar to Gabe's. For example, you have a board, you have a member of the council that sends out an email to all other city councils to, we'll say a 7th council member underneath the guise of its informational and educational, but within that same email, it is stated that you will be disciplined. And then it's prefaced that this is an educational, informational email. To me, that's actually pushing the boundaries of educational and informational, especially when you use an affirmative statement like will be versus maybe. Language, I mean, it goes to, on behalf of, knowing and intentionally.
Right. So, I mean, I think that would, yes, perhaps be relevant to determining intent. Okay. Any additional comments on the serial communication rule, intermediaries? Okay. We're gonna break early. Let's briefly discuss next steps. So we have a 2-week break. In those 2 weeks, you will get a whole new set of the next tranche of rules, which are all the what of meetings, you know, the or the how of meetings, the notices. And yes, as much as I would love to define what is a reasonable amount of time required for a regular meeting notice, I'm not going to do so. As well as the complaint, grievance, and rules specific to that process and procedure and the commission's complaint process. You will receive those, I would like to say by Friday, but I have a rather large report to write before then. So by Tuesday, and have an opportunity to look at them before we meet next. And I will continue taking your comments and seeing if we can refine the rules you've already seen in the meantime. Becky, you wanted to talk about schedule, yes?
Yes, so our next scheduled meeting is June 10th, and then we also are putting on the calendar a meeting on June 17th and June 24th, just so that we already have it on the calendars in case that we need them. I mean, we would like to have it nice wrapped up in a bow before then, but on the off chance that we don't, we would like you to put those on your calendar, same time, 1 to 4 for 3 hours, just in case. That way, and we'll put them up on our website and get them on our calendar as well. So just a heads up. That way everyone is on the same page. So we still have the meeting that's coming out on the 10th, but we're also adding the 17th and the 24th of June as well.
Okay.
And then we also have a message and said, what are the dates you just announced? June, I'll put it in the chat for you, June 17th and June 24th. 1 to 4 p.m.
And yes, Chris, we will send out some sort of calendar invite to preserve, etc.
Yes, yeah, you can expect communications from the staff.
Okay. All right. Obviously, feel free to continue sending in to the email any comments or suggestions that you have on the rules so far. And I appreciate you joining us today. Oh, Joe, sorry. I didn't mean to. You have your hands up.
That's okay. I just have a little quick on discussion, on the definition of discussion.
Okay.
You use the phrase pictorial. I would like to see digital image or icon used. And according to Oxford's dictionary definition, it means to express an idea, emotion, or thought. And it's actually from Japanese origin, from Mojai.
I will look into that. Okay. Well, I will let you all go a little early today, and my staff will be in touch in terms of survey and getting the new meeting dates sent out. Thank you, everyone.